All right, so today we're going to pull back the curtain on something really important: how India's criminal justice system actually works when it comes to the most serious crimes, especially under the new laws. We're going to follow the story of a trial from start to finish.
You ever wonder what actually happens when someone is accused of a major crime like murder? It's not just one dramatic courtroom moment like you see in the movies. The whole thing is a carefully structured journey called a session trial, and it's all designed to be fair and ultimately to get to the truth.
So a session trial is the big one. It's the highest level of criminal trial, save for the most severe offenses. And it's all laid out in the new rulebook, the Bharatiya Nagarik Suraksha Sanhita, or BNSS for short. So let's walk through it, step by step, and see how the story unfolds.
Now, you might think a trial kicks off with a witness on the stand, right? But nope, it actually starts much earlier with a really critical first hearing. You can think of this stage as a gatekeeper, basically deciding if there's enough substance here to even have a trial in the first place. This opening stage has three key parts. First, the public prosecutor lays out their case, all the allegations, all the evidence they think they have. Then the court goes through every single record and document. And here's the important part. Right away, the court hears from both sides, the prosecution and the defense. Everyone gets a voice from the very beginning.
So, after hearing from both sides, the judge has to answer one fundamental question. It sounds fancy, prima facie, but it just means at first look. Is there really a case here, or is this all just smoke and mirrors? And the answer to that question creates a huge fork in the road for the accused.
And here are the two paths. If the judge looks at everything and thinks, you know what, this is just too weak, there's nothing here, the accused is discharged. They walk free. The case is over, right then and there. But if the judge decides there is enough evidence to move forward, then the court formally frames the charges, and that's when the trial officially, truly begins.
Okay, so the charges are framed. Now we move into phase 2, the plea. At this point, the spotlight swings directly onto the accused person. They are now at the absolute center of the proceedings.
And here's a really crucial point. The court doesn't just hand over a document. The judge has to read the charges out loud and explain them clearly, so the accused understands exactly what they're up against. This isn't just a formality, it's a basic principle of justice. You have to know what you're accused of to even begin to defend yourself.
So once everything is explained, the court asks this very direct, very powerful question. And this moment presents the accused with a massive choice, a decision that will dictate exactly what happens next.
If the answer is, I plead guilty, the whole trial phase just gets skipped. The judge records the plea, and the case moves directly to conviction and then sentencing. But if the accused says, I do not plead guilty, or I want a trial, they're choosing to fight. And that decision launches us right into the heart of the whole process, the battle of evidence.
This is the part of the trial we all picture, right? Lawyers making arguments, witnesses testifying, evidence being presented. It's where each side gets to build their story and try to poke holes in the others, piece by piece, right in front of the judge.
The prosecution always goes first. Their mission, to prove guilt beyond a reasonable doubt. So they call their witnesses, they present their documents, and they build their case. And once they've presented everything they have, the prosecutor will literally say, the prosecution rests.
Now check this out, because this is a really important safety check built right into the system. After the prosecution rests, but before the defense even starts, the judge takes a hard look at the evidence. And if they decide it's just not strong enough, that there's no way it could lead to a conviction, they can acquit the accused on the spot. Game over. But let's say the prosecution's case is strong enough to continue. Well, now the ball is in the defense's court. It's their turn to fight back. They get to challenge the prosecution's evidence, bring in their own witnesses, and present their own documents to create doubt or offer a completely different version of events.
So, after every witness is spoken and every document has been seen, we get to the grand finale of the evidence phase, the final arguments. This is the last chance for both sides to tie everything together, to tell the judge why their side of the story is the right one, and make one last, powerful pitch.
The arguments are done. The evidence is all in. The trial has reached its climax. Now, all that's left is for the judge to make the final call. So what happens next? The judge has two choices. They can give the judgment right then and there, or if it's a complicated case, they can reserve the judgment to think it over. But, and this is key, the law puts a strict deadline on it. If they reserve judgment, they have to deliver it within 45 days. And that judgment can only go one of two ways. It's either an acquittal, in Hindi, bari, which means the accused is found not guilty and is set free, or
It's a conviction, doshi, which means the judge has found the person guilty of the crime.
A conviction isn't the final word on punishment, though. The process actually splits in two. A totally separate hearing is held just to decide on the sentence. This gives both sides a chance to argue what an appropriate punishment should be, based on the crime, the person's background, and everything else.
This brings us to one last absolutely vital safeguard in the system. In most cases, the sentence from the session judge is final. But what happens when the punishment is the most extreme, the most irreversible one there is? Well, the law adds one more layer of protection.
And this is so important to understand. A death sentence handed down by a court of session is not actually final. Think of it more as a recommendation. It has no legal power until a higher court, the High Court, reviews the entire case from top to bottom and confirms it. This mandatory review really highlights just how much responsibility is built into every single stage of this journey, from that very first question of, is there even a case, all the way to a decision that could literally mean life or death.